your cell phones. And, we're going to begin this morning with the case of Sasser v. Sasser. And if you could please ask the attorneys to identify themselves for the record.
Chris Donovan, commentator.
Mark Ricker, ICK, we have.
Okay. All right, Mr. Donovan, you are recognized. How much time would you like to reserve, if any?
5.
Okay. You're recognized.
May it please the court. The initial brief identified 2 grounds for reversal, but today I'd like to focus on just the first ground and stand on my briefs with respect to the second ground. The first ground asks the issue of whether or not section 90.11.1's 20-year deadline, statute of limitations deadline, applies to support payment judgments, particularly the 2004 judgment. The 5 other district courts of appeal, beginning with the first DCA's Omar decision, and then the the 5th DCA's Popper decision, has basically answered this question in the negative, stating that the statute of limitations.
So I was kind of a little surprised the way you organized your brief. You really hit the DCA split hard, and then you said, whatever you do with the DCA split, this was an alimony. And I kind of thought it made sense to do the other person. We don't get into the DCA split unless it's alimony. And frankly, I didn't think it was alimony. It literally says in lieu of alimony. So why did you organize it that way? It seemed to me like the much straightforward issue was this isn't alimony. And I don't think that means you win. I've got some questions about it, but
Sure.
Did you find it to be a close call as to whether this is alimony? Because the implication there, the way you organized your brief was you thought that was the stronger argument, was take this side in the DCA split, which I'm not saying you're wrong about which side to take or right. I'm just saying that it seems like I would have expected the first issue, just as a point of logical analysis and strength of argument, to be this isn't alimony. So what am I missing in terms of how you organized your brief?
No, I think that in terms of how I organized my brief, I went back and forth on which one to start first. I think I decided to just go squarely in challenging the other 50 DCA splits, because the trial court didn't really want to hear about the distinction between whether this was alimony or not alimony. And in fact suggested, although I disagree with it, suggested that my client had somehow conceded that this was alimony. So I decided, I made a split decision. I think that either one of those could have begun first. I also liked the reason why I structured it that way is because then it provides me an opportunity to provide the general law of judgments first, and then move into addressing the exception.
Well, the judgment literally says in lieu of alimony, so I don't think this is alimony. The issue I had with your argument was, it seems to me a little internally contradictory. All right, so you see actions must be filed within 20 years. Statutes of limitations, they don't eliminate ongoing actions. It just requires you to file the action within the limitations period, right? So if you file an action or a proceeding within the 20-year time limit, it seems like you have a right to have it litigated. And what you say to that in your brief is that, well, these were motions. They weren't independent actions, okay? So there was no action filed. But then you also go on to say that an action under 9511 includes proceedings, which is broader than actions, and includes any procedural means for seeking redress. And certainly a proceeding supplementary, or a motion for garnishment, of the types of things you would do for execution, those are certainly proceedings for seeking redress. So I guess my question is, wouldn't the types of things at issue here, the motions, proceedings, supplementary, wouldn't they be included within the definition of proceedings that you point out? Because the way it seems to me is you seem to want to say that these are proceedings within the scope of 9511, so they're barred. But if they're proceedings within the scope of 9511, that also means they were commenced within 20 years. So can you square that for me?
Sure. I think that the Supreme Court's decision in Salinas versus Ramsey squared that. And I think they wrestled with a similar tension.
That's discovery.
I'm sorry?
That was discovery, right?
Well, that was discovery, but I think that I don't believe that Salinas was limited to just discovery. It basically said all forms of enforcement of the original judgment. In fact, that all Salinas reaffirmed the Supreme Court's Massey versus Pineapple Orange decision, as well as the Supreme Court's Young versus McKenzie decisions, which concerned execution on judgments and judgment liens. And it approved the Fourth District Court of Appeals Bershon decision, which involved garnishments. In other words, as far as I read Salinas, it was not limiting proceeding as bright, it was not making proceedings.
What was the timeline of the garnishment in Bershon? When was it filed compared to the statute of limitations period? And like, as opposed to filed versus completed. So here's my point. Say you've got 20 years and you get a writ of garnishment the day before the 20-year limit, okay? And the bank actually answers 2 days after the limit or a week after the limit. Have you not commenced your garnishment proceeding within the 20-year limit?
No, Your Honor. You've commenced it within the 20-year limit, but the statute of limitations isn't limited to just proceeding. A garnishment is not an action on a judgment. It requires an entirely independent lawsuit to renew the 20-year statute of limitations, which is basically what Bershon.
No, but I agree. You need a new lawsuit to extend the statute of limitations. I'm talking about whether the statute of limitations was complied with, right? Because a garnishment is the definition you give for proceeding, you pointed out, in the statute that applies, because they define action to include proceedings. It's not just common law action as used in the statute, include proceedings, which is any, procedural means of seeking redress. A garnishment is certainly a procedural means of seeking redress. And the statute uses the word commenced, right? So if you file for your garnishment within the 20 years, you've commenced the garnishment proceeding, haven't you? You haven't completed it, but you've commenced it.
You've commenced a garnishment proceeding, but that is insufficient to extend the original judgments.
No. I'm not saying you're extending the statute of limitations. I'm saying you've complied with the statute of limitations, right? Like, just think about a 5-year statute of limitations on a contract claim, or 4 or 5 years, whatever it is. If you file that a week before the statute of limitations, you get to litigate your suit. You didn't extend the statute of limitations. The statute of limitations is still 5 years, but you commenced within the 5 years, right? So you would get to pursue that suit. And that's what the analogy I'm giving with the garnishment is. If you file your garnishment within the 20 years, yes, you might not get to file a new garnishment 2 weeks later because now you're outside the 20 years. But that garnishment was commenced within the 20 years, was it not?
Not according to the Salinas, Massey, and Young precedents, Your Honor, nor I think under the Bershon precedent, which this court's not bound by necessarily, but it was approved by Salinas, that the proceeding for garnishment, proceeding is not as broad for purposes of 9011 that would allow you to avoid 9011 statute of limitations.
What was the timeline for the garnishment in Bershon?
Let me
If you
try.
don't, that's okay. You can address it on rebuttal. I don't want to get up your time.
Okay, that's fine. Yeah.
Let me ask you this then. If I think Salinas, I'm not saying I agree with your interpretation of Salinas, but assuming your interpretation of Salinas is correct, what if I just think Salinas is wrong? All right, so I have to comply with all Supreme Court holdings, right? Obviously, I don't have to comply with like logical extensions or dicta, right?
Okay.
So Salinas, whatever you think about how the logic might apply here, concerned discovery, didn't it?
Yes, it concerned discovery, but Massey versus Pineapple Orange, which is a Supreme Court case, I believe it concerned a deficiency execution on a deficiency degree. And it was similar to the scenario that you're asking about, where they filed their levy a couple of days before the 20-year mark. And then the sheriff didn't start trying to actually, collect all the property to execute it until after the 20-year mark. And the Supreme Court in the 1924 Massey versus Pineapple Orange case said, no, all forms of judgment enforcement must stop. That simply because you obtained, in that case, they had obtained a writ of sorry fate. I'm sorry.
Did the statute in 1924 include the definition of proceeding that it has now?
So
Didn't they have that in the 70s or something?
that, yes, the definition of action was defined under 95.011. It was added in the 1970s. Correct. Yes.
Okay, so I don't think a 1924 case helps you when the definition of the statute at issue here was added in the 70s.
Other than the fact that Salinas approved Bershon's fourth DCA case, which relied and approved the Massey decision and relied on the Massey decision, continue relying on the Massey decision.
But that would be dicta too, right? And then there's what is there? Can you give me anything about a Pedroza analysis on that? Means that's a holding I've got to follow.
I'm sorry, repeat that.
I mean, a kind of a logical approval of we like a case, that's not part of a holding, is it, that I have to follow?
Except that it was part of the, I mean, in dicta, or so the difference between dicta and holding, respectfully, Your Honor, is that all of the reasons that support the underlying decision of the appellate court is holding. Anything out extraneous to that.
Correct,
is
but it's,
dicta.
so it's a Pedroza analysis, right? So it's the decisions in a line of reasoning that lead to the judgment based on the facts of the case.
Correct.
Facts of the case where that was discovery.
Okay, but if Your Honor, for a moment, let's assume for the sake that you could distinguish Salinas based on discovery. It's discovery in aid of execution. It's not discovery in a vacuum.
Well, but discovery doesn't seek a remedy, right? Discovery is something you gather in order to later seek remedies, right? Whereas a garnishment or, proceeding supplementary, you're going after money, right? I mean, that's much more in line with the seek redress definition than discovery to me, is it not?
What would be the point of pursuing discovery or denying discovery beyond the 20-year mark if you couldn't enforce the underlying judgment? I mean, it's discovery in aid of execution for a reason. If execution is no longer valid after 20 years, then logical extension of that is that discovery wouldn't be, you couldn't continue discovering a judgment that's no longer enforceable. And I think that's part of why the Massey decision and the Young versus McKenzie decision are still valid and not just dicta in the Salinas case, because they were integral part of the decision-making process in reaching the holding in Salinas.
Is it strike you as inconsistent in how you're asking us to interpret how execution proceedings work and collection proceedings versus how actual actions work, right? If you've got a statute of limitations on a contract or negligence claim, you've got a 4 or 5 or 2 year statute of limitations. If you start the proceeding within the statute of limitations, you're golden. As we're in the execution context and the collection context, you're asking us to say the proceedings must be completed within the statute of limitations. That would mean that these proceedings work differently than, statute of limitations on civil causes of action, right?
I don't believe so, not based on how action on a judgment or decree has long been recognized. That as Salinas pointed out, it does require an independent action separate from the original action.
Well, but the independent action, I think we're disconnecting a little bit. Independent action is what you do to extend the statute of limitations. So you're coming up in your 20 years and you've got to file an action to renew it, right?
Okay.
Totally same page. Agree with you there. What I'm talking about is the mechanism for complying with the existing statute of limitations. So in the, breach of contract context, you've got 5 years or 4 years, whichever it is. If you file your breach of contract action within that 4 years, you've complied with the statute of limitations, even if your suit isn't finished until outside the 4 years, right? You just have to file and start it, commence. And in the collection, in an execution realm, you're asking us to treat it differently, that your execution proceeding must just be commenced within the statute of limitations, but must be completed within the statute of limitations. And that even if it's commenced within the 20 years, if you're not done within the 20 years, you're cut off and it ends even though it's ongoing. That's not how the statute of limitations works for, civil actions, right? You're asking us to treat them differently.
I respectfully, I'm not sure that I am. In modern day era, yeah, I can see how it'd be difficult, that's difficult to wrestle with. And I spent a lot of time thinking about it. But I think that when you look at the definition of action on a judgment, every judgment essentially gives rise to a new lawsuit called an action on a judgment. So in order to renew past the 20 years, just like a regular civil action, in order to have that right to sue to extend the deadline, one must file a new lawsuit on an action on a judgment, not merely file proceedings.
It seems like what you're giving me is a rationale and a historical reasoning why they're treated differently, rather than really denying that they're treated differently. When you have a negligence action, you've got to file it, commence it within the statute. And as long as you do that, you can finish it afterwards. And you're asking us to say that when you commence a collection proceeding, you've got to not just commence it within your statute, but finish it within the statute or else it cuts off halfway through. And what you gave me is like, well, Judge, look at the history. And that's a reason to treat them differently. It doesn't really deny that you're treating them differently, does it?
I'd have to think about that more. Your Honor. I mean, maybe you're right. Maybe they are treated differently. Even if that is the case, the Supreme Court has already spoken that that all judgments should be, in order to continue enforcing them after the 20-year mark, in order to continue proceedings supplementary or proceedings for garnishment, you have to renew them after the 20-year mark.
So your position is that nothing that they did as far as commencing these actions qualifies.
Correct, Your Honor. Because each one of them was a proceeding contained within the original lawsuit to enforce the original judgment, which under the cases that I've said, the Massey, the Young, each one, and Bershawn, each one of those were very similar to here, where they filed enforcement actions, be it a garnishment proceeding or a request to reduce the amount to the arrearages amount in order to execute on them. Each one of those is very similar to the Young, Massey, and Salinas precedents.
Can you give, before you go, just your best, give me your best analysis on Salinas as to why why the holding of Salinas, as opposed to the logic or the, an extension, why the holding of Salinas, which is what we're bound to follow, would apply here, given that it was discovery.
I mean, I think that my best analysis on that is that since it's discovery and aid of execution, it's connected to the enforcement proceedings. And so all enforcement proceedings, including discovery, must end if you haven't filed your separate action to renew the judgment. I'm not sure. I think I'm eating into my.
Yes, you are.
Okay, then I'll
We'll-
refrain.
All right. All right. Rickard, you're recognized.
Morning, may it please the court, Mark Rickard for the appellee. What I think the court is getting at is a question of the enforceability, all these post-judgment. None of those are applicable. What we have in this case is a continuing obligation. It does not reach the level of a final executable judgment. All of the cases that are relied upon by the appellant in this case deal with execution on a judgment. All these post-judgment cases, whether it be execution and levy, whether it be garnishment, whether it be proceeding supplementary, you have to have a money judgment, a final judgment that says this is what's owed and we're seeking satisfaction. Proceeding supplementary specifically are for the purpose of obtaining satisfaction of judgment. When you have a judgment in equity where there is a continuing or ongoing obligation, such as in the present matter, you can't execute on it. There's no fixed dollar amount which can be put in a writ of execution. The case that I relied upon, which is also what the court put in its order, is the Kosh case. That's the Florida Supreme Court saying that it's a difference in a judgment whether you have a fixed amount that is owed versus, or a liquidated amount versus an ongoing obligation. What we have here, and why all of the districts other than this one yet have said that it does not, a statute of limitations does not apply in alimony, is because it's not a fixed amount due. There's no execution issue.
The council, first of all, I don't think this is alimony. The judgment literally says in lieu of alimony. I don't see how everybody thought it was alimony. It literally says this is not alimony. In lieu of alimony means not alimony. So, but in terms of the fixed requirements, I mean, there were fixed things in the 2004 judgment that, the husband was required to do, or they're not. I mean, transfer interest in a company, make certain make the financial payments. I get that some things were reserved, but there were it certainly said judgment on it, right? And it certainly ordered him to do specific things, did it not?
It did. However, that doesn't make the entire judgment executable. In order to do that, you have to have a fixed amount. Let me give an example to the court, and this is a case actually provided by the appellant, is the Webb case.
Does the statute say executable judgments, or does it say any judgment?
Which statute are we?
9511.
9511 is for the enforcement of judgments.
Judgments or decrees. It doesn't say
Right.
judgments, executable judgments, does it?
Ninety-five eleven is an action on a judgment or decree of a court of record of this state. But as an example, again, proceeding supplementary, the courts have found that that's not an action on a judgment. That it's a proceeding within the same case. You don't have to file a separate action. It's similar to what Your Honor referenced before, where if you have a continuing proceeding within the same case, you don't have to file a new suit.
Under that rationale, wouldn't judgments just never expire?
Judgments in this instance would not. If you had permanent alimony, it would never expire until the death of the party. In this case, the ongoing obligation was until 2024. So that's the date that it would
Yeah,
expire.
I'm not buying this as alimony. So if you
Well,
want to convince me, I
that-
don't think it was alimony. It literally says it's not alimony.
But it's an ongoing obligation. And that's what the courts refer to. The Kosh case doesn't say alimony, it says ongoing obligation. It's kind of a semantics there. If there's,
Similar to the Supreme Court's case, I think the name that looked at the mortgage requirement because the mortgage was ongoing, that there would be some default, but they said that the stuff that had defaulted in the past was gone. So you're basically arguing that if it was over 20 years, you couldn't go back and collect that, but the stuff that was continuing wouldn't default up to the point in time.
if I could, and that, look, we go back and I filed a notice of supplemental authority that the case of Dickinson v. Sharp, and it's a 1927 case from the Florida Supreme Court. But the justice who wrote the opinion gave a very pertinent analysis of this, saying that a decree, in that case, we were dealing with permanent alimony, is not one which may be paid off and discharged. It runs in installments so long as both parties are living, unless vacated by order of the court of competent jurisdiction. So in there, you have one that is ongoing until the death. It's not limited by any statutory period. It says, therefore, it is impossible to determine what amount of money will be required to meet the exigencies of the decree. It is clear that execution would not issue upon a decree like the one before the court at this time. And the only way in which an execution would be procurable would be for the claimant under the decree to petition the court for an adjudication against the person against whom the decree was rendered for default in payment on installments of the adjudication, fixing the amount then due and payable while under the terms of the decree for an order execution for a specific amount. Again, we have in this case a judgment of dissolution, which incorporated a settlement agreement, which provided for ongoing payments, which had not even yet been determined as to their amounts. They were to be calculated. They had to have an accountant go in and determine how much money this company was making and how much of that then would be attributed towards
You're
support.
basically saying treat judgments like, any other contractual obligation, right? Where the statute kind of runs from the breach. I'm not sure that's how judgments work. And there's lots of judgments that require, things other than just that pay this amount within 30 days. And we don't say they're not judgments, right? There's judgments for business divorces, right? Business divorces where you're dividing up assets and things. Not every judgment is just pure pay this amount of money. And I've never heard anyone argue that means they're not a judgment like any other judgment for purposes of a statute of limitations.
Well,
You're basically saying like, well, there wasn't any violation of the judgment until he didn't pay. Is what I'm hearing from you?
well, that would be where there was a breach. If you remember, a statute of limitations runs from the last element of the cause of action.
Well, that's what I'm saying. I don't think that anyone is breaching a judgment. A judgment is not a contract. A judgment is a judgment. And, you violate a judgment, and can be subject to, collection proceedings if it's to pay money or, other remedies for other types of judgment. But that's what I'm saying, kind of the analogy you're making of like, this is a breach of the judgment and it would run from the violation. I'm just not sure that's how judgments work for purposes of statute of limitations.
Well, for a typical money judgment, it is. because a typical money judgment is for an amount certain on the date the judgment is entered for which execution issues.
Let me ask you this, with a typical money judgment that just says, pay this much money, pay $10,000. You get in Florida 30 days to pay before you're subject to collection proceedings, right?
Well,
Typically.
yes and no.
Okay.
The execution on a judgment is it's immediately due and payable in full, but there is a 30-day stay in order to execute on it because you have the period in which a review can be requested. So they do have a statutory stay period. So it doesn't change the date in which the amount is due in full and in total, which is when it's entered. But you can't enforce it because there's a stay period. That's different than saying when it's actually owed.
Question. This judgment initially basically had payments from 2004 to 2014, 2014 to 2019. Do typical money judgments have that?
Well, the judgment had payments due from 2004 to 2020.
Right, I'm just saying, the first set was 2004 to 2014, 146.9, 2014 to 2019, 100,000.
Okay.
Do typical judgments you get when you don't pay your car off or something say, hey, pay this much money every year for the next 20 years?
No, you're going to get a full amount. It's going to liquidate the amount. This is an unliquidated amount. A final judgment that is executable has to have a liquidated amount. And that's the issue that we're dealing with here. That's the, if it were liquidated, it would be a different question. But again, I wanted to point the court to Webb, which is one of appellant's cases. The second DCA, this is from 2020. Now that dealt with a property settlement agreement, which was liquidated. But in that case, they said that there is a 20-year statute of limitations that ran from the date that it was liquidated, was the date of the judgment. And they said it is 20 years. They said that because her motion to enforce was, quote, an action on a judgment or decree or a court record of the state, end quote, that when she filed it one day before the 20 years expired, that was sufficient under the statute. It's like Judge Mize was saying that once you file it, that's it. It's the limitation is when do you file it? So even if, well, I'm saying the statute does not apply because it's unliquidated. But even if you apply the statute, it has to apply, and we filed the motion prior to that expiration. And that's sufficient.
I get you have issues about when the statute of limitations started. But assuming the statute of limitations started in 2004, do you agree with me that and you didn't renew the judgment, 20 years you're cut off from filing new things, right? So I'm not asking you to see that the statute started running in 2004, but just assume it did for purposes of this question, right? I'm not taking it as a concession. But you couldn't go down and file new proceedings supplementary, could you?
Well, two questions. You can't file a new action if there's no cause of action to file, we've already got it. Proceeding supplementary require execution. Proceeding supplementary to execution. So you can't ask for a proceeding where the condition precedent is that you have outstanding execution and the
I guess what I'm
legislature
saying
said
is,
you have to file an affidavit.
do you agree that the statute of limitations, it does cut off new collection proceedings after 20 years from whenever it starts running?
On whatever amount is executable, yes. On the money, on the specific value, and other cases, it's not even money, it's exchange of property.
Okay, I get you have a theory on when the statute starts running, and I'm not agreeing or disagreeing with it. I'm just asking you, whenever it starts running, 20 years from that, unless you've renewed it, you can't file new writs or collection proceedings, correct?
Well, correct in a sense, but let me back up because there's a statute of repose which runs from a date certain. That when an event occurs, you have a statute of repose, which is a cutoff point. A statute of limitations is different, and it runs from each cause of action. It doesn't run from a date, it runs from the last element of the cause of action. And when you're filing for a money judgment, it's when was that accrued? If payment is due in 2023 and you don't make the payment when it's due, that's the last element on a claim for the amount owed.
All right,
So-
Counselor, but I understand your theory on that, but when I ask you a question, I want you to answer my question. Give me the answer to my question.
Maybe I didn't understand it.
So whenever it does start, statute of limitations, it begins. You got 20 years. At the end of that 20 years, you cannot file new collection proceedings, can you? unless
If
you
it, if
renewed
your
it.
claim is expired, no, you cannot.
I want to ask you about the prejudgment interest. Because it didn't seem in your brief that you disputed that the accountant's report was hearsay. It didn't seem like you disputed that the former wife had no independent recollection that could be refreshed. That's the only argument made by the appellant, and you just didn't dispute it at all. Your argument seems to be that not calculating interest in the prior judgment was a clerical error. And number one, I can't see how the purposeful decision of a trial court not to calculate something and save it for later could be a clerical error. When the trial court purposely does something, that seems to be the opposite of clerical error. And then even if it was a clerical error, I'm not seeing how that has anything to do with, all right, now that the court is in a proceeding to correct it or determine prejudgment interest, the fact that it was a clerical error, I'm not seeing why that has anything to do with whether this report was hearsay and whether it could be relied upon to determine the amount of the prejudgment interest. That seemed just to me to be totally non-responsive to the issue. The only other thing I said, saw you say in the brief was that they didn't give an alternative calculation, which again, just has nothing to do with whether this document was hearsay and whether it can be used to refresh your recollection. So I've got an argument from the appellant. This was hearsay. It was preserved. They made that argument below. They made it with us and said, this is not your client testified. She didn't have an independent recollection. That seems to be what the transcript said. I've got you not responding to that argument at all and giving me two arguments that seem completely to miss the point. Other than what you stated in your brief, is there any realistic argument that we should not reverse in the prejudgment interest?
Yes, the court did award interest. In the judgment, the court said that it would earn interest on it. It specifically says that.
Well, counsel, I'm not saying that the original judgment didn't award interest, but you now had a hearing where the amount was determined, and that was an evidentiary proceeding. And they made an evidentiary objection, which seems to me you do not dispute their objection was correct. So the issue was not whether or not the original judgment awarded interest. The issue was whether the rules of evidence were followed at the proceeding to determine that amount of interest. And it doesn't seem to me that you dispute at all that the rules of evidence were not followed. They made a valid objection. The court erroneously overruled it. Where am I going wrong?
Well, the evidence that we presented was the testimony, and it was refreshed.
The counsel, she said, I don't know this. I can only read off the paper. I mean, she said, I don't have an independent recollection of this.
Right, but those papers were record documents because those were obtained by the accountant who was ordered by the court to do these calculations.
It's what rule of evidence allows a witness to read any document from the record, regardless of whether they have any personal knowledge of it.
Refreshing recollection allows you to look at any document.
Yeah, refresh.
Well, she did.
It allows you to refresh a document, to look at a document that refreshes your recollection. She said, I don't have any recollection. I can only read a document. That's not a refreshing recollection. That's their point.
I don't recall that specific testimony off the top of my head here, because my recollection of it, what transpired was that she was saying that she knew at the time and that she had this document which would refresh what she knew at the time.
But let me ask you, at the time, she got it from a out-of-court person, the CPA. She did not calculate the interest herself. So at the time, she would have got it from a third party, did not calculate it or check it, and then it was brought into that hearing.
Yeah, this was the presentation of the accountant as ordered by the court to do the calculations that were presented to the court in the original hearing. So the court already had those. They were already reviewed by the court initially. They were not, for unknown reason, included in the judgment. And I can't answer as to why.
Been included in the judgment years ago doesn't mean that you get to just go read everything from the record back into a party who didn't have that information and that knowledge at the time.
Well, there you get into the argument that the judge relied on, which is the estoppel and the prejudice, that when you have over $1 million worth of interest that is accrued, and that
You're asking us to just start letting trial judges pull a number out because they think equitably this is such a large number, we've got to throw something on there without getting it on paper through proper evidentiary channels?
well, you've got the numbers, the principal numbers in front of you. It's not something that's just pulled out of the air. The calculations actually make sense when you look at the record of the payments that were there and the actual numbers themselves. And the interest rate
You
is,
don't get to pull out numbers and say these make sense. You have to get them in through some proper evidentiary tool, right? And in this case, you had a witness who said, I don't know these numbers. I can only read a document. I have no recollection of these numbers. Just because there's some document and you say, Judge, I think this makes sense. That's not how evidence works, is it?
well, then it can be remanded to the court to take additional evidence. Because the prejudice is enormous in this instance.
But I mean, the
And-
parties get to just not meet their evidentiary burden and then say, give me a do-over. I didn't put in evidence for my claim.
In this case, you're not dealing with a principal claim. You're dealing with a mathematical calculation that is the court's responsibility, not the parties. That was the Florida Supreme Court that said that. It is a responsibility of the court, not the party, to do the calculation of interest.
And we know what the judgment is to base it upon. That we don't have that in any document. We only have that through her testimony.
I'm sorry, Your Honor, we don't have what? We did.
The amounts upon which to determine the judgment.
We have the original documents that were prepared by the accountant.
The accountant didn't testify.
The accountant, I don't believe, is available to testify.
Okay, well, you don't just get to bypass the rules of evidence because you say, well, I couldn't find this person. Like you have to find some way through the rules of evidence to get your evidence in. Aren't you, counselor? And isn't that what the rules of evidence are for?
And also, couldn't you have another accountant do the same calculations and bring them in? Just because that first accountant may not be here anymore, you could still present an evidentiary basis at the trial.
Which is why the proper procedure, if the court doesn't accept this, would be to remand it for an additional evidentiary hearing to determine those amounts. You're dealing with what would be an error of the court.
We're
This
also
was-
dealing with an error of the course.
Well, again, I mean, but this is something that is ministerial. It's not the burden of the party it was already presented and wasn't included.
But to Judge Rapel's point, why would we send it back for a do-over when the attorney could have brought somebody in then? You know, why should we send it back and say, okay, go get a different account because you chose not to get one the first time?
Well, we had no objections to anything that we presented going into the hearing. And, without even knowing that at the hearing that they were going to bring up these objections,
Was there some deadline for them to make objections? Was there some scheduling order they violated? And then did you raise that at the hearing?
well, I think I don't actually remember what was said at the hearing.
Unless
I'm
you've
not gonna
got,
represent-
unless you've got some deadline they violated to give you an objection, and then you raising that at the hearing saying, Judge, they missed their deadline to object. I'm not sure why it's relevant for you to say, well, we didn't know they were gonna object, like you.
Well, you don't want surprise argument at a hearing.
But
so
the way-
reasonable time.
The way we deal that is to set deadlines, and then if somebody, and you can ask a trial court judge, we've got a hearing coming up, can you set us some deadlines? Happens all the time. And then if they violate those deadlines, then you raise it at the hearing. I didn't see anything at the hearing where you said, hey, judge, they had a deadline to object to this. They didn't object. They blew the deadline. There's nothing like that on the record.
Well, I agree that if we had asked for deadlines and had them set, that you'd have that. But without those deadlines set, it has to be a reasonable time.
Okay.
Counsel, you're a minute over time.
Thank you.
Thank you, sir.
Counsel, you're recognized.
Thank you, may it please the court. I'd like to spend the last few minutes of my time trying to respond to some of Judge Mize's questions during my presentation. I believe one of the questions you asked was, when did the garnishment proceeding begin in Bouchon? In that scenario, that case involved a foreign judgment. And so it actually had begun 11 years after the original judgment, but I think it was technically 5 years after the writ of garnishment petition was technically 5 years after it was registered. And the court found that that it was untimely. And I think that the larger point that Your Honor was moving towards is the definition of proceeding, in that in Bouchon, had they started the garnishment proceeding prior to the expiration of the 5-year deadline for foreign judgments, would that have changed the result in Bouchon? And with respects to, because of Salinas, though, I do not think so, because I know that Your Honor wants to limit Salinas to discovery and aid of execution, but I believe the judgment was a bit broader, because the Supreme Court on page 571 said that for the reasons that follow, we agree with the 4th District holding Bouchon that collection activity on a federal judgment is not governed by section 9511(2)A, but instead is permitted for the 20-year life of the judgment. So I think that while the facts of that case certainly involved discovery and aid of execution, the breadth of the holding in that case was much broader and involved all collection activity.
Well, can that be possible? I mean, so this, an opinion saying, just saying a line, we agree with this, doesn't make that the holding, right? I mean, that's the whole thing, is dicta is something in the opinion said by the court that is nonetheless not a holding. Right? And so what you just said was, despite the facts being discovery, this is still a holding. And that seems to me to just be completely violative of the Pedroza analysis, right? Pedroza tells us holding is based on the facts. So I don't see how you can ever say, despite the facts, the holding is this. That seems to be the opposite of how you determine a holding.
Other than the fact that the court also approved the Bershon decision in general, which it did go through the analysis and found the statute of limitations applied. And in terms of the definition of proceeding, I think that the Salinas case goes into that and talks about, yes, it can be a broad definition, but in the context of 95.011, the Supreme Court of Salinas did not think it was quite as broad because, and that's provided, that discussion is provided for at page 573, where it says that if proceeding in this context meant any step of a lawsuit, as the judgment debtor seems to suggest, then the statute would require the lawsuit to both begin and end within the limitations period. As the final hearing or trial would be barred if it hadn't occurred after the end of the limitations period. But the legislature didn't state that. It's emphasized that the action had to be begun before the 20-year period. And 95.011 defines action to include, to be encompassing of both civil actions or proceedings. So the entire independent lawsuit had to have been filed within the 20-year period. Merely filing other forms of final processes was insufficient. Therefore, this court should reverse all of the orders that are on appeal and remand with instructions to cease all collection on the 2004 judgment. Thank you.
Okay, thank you. Anything else? All right, court's in recess. Thank you.